Below is a structured and legally grounded article that presents a full picture of arbitration jurisdiction in China, contrasts it with court jurisdiction, and explains three different scenarios regarding domestic, foreign-related, and free trade zone-related arbitration clauses, in line with the current Chinese law and practice. Jurisdiction of arbitration in China, a comparative and practical overview. Jurisdiction is a core issue in dispute resolution. In China, arbitration jurisdiction differs fundamentally from court jurisdiction, particularly in terms of party autonomy, geographical flexibility, and the treatment of foreign-related elements. Understanding those distinctions is essential when drafting dispute resolution clauses in commercial contracts. This article provides a comprehensive overview of 1. The difference between arbitration jurisdiction and court jurisdiction. 2. The validity of non-local or so-called abandoned arbitration clauses. 3. The limits on choosing foreign arbitration institutions in purely domestic disputes. 4. Special rules applicable to foreign-related contracts and China's free trade zones. Court jurisdiction, statutory and restrictive under the civil procedure law of the PRC. Court jurisdiction is largely mandatory and statutory. For contractual disputes, jurisdiction generally lies with the court as the defendant's domicile, or the court as the place of contract performance. Although parties may agree on a jurisdiction clause, such agreement is subject to strict limits. The chosen court must have an actual connection with the dispute. For example, place of performance, place of selling, subject matter location. Parties cannot freely choose any court without a genuine nexus. For example, if both parties are domiciled in Beijing and the contract is performed in Beijing, they cannot validly agree that the Shanghai courts shall have jurisdiction unless the dispute has a close connection with Shanghai. Arbitration jurisdiction, party autonomy as the core principle. By contrast, arbitration in China is governed preliminarily by the arbitration law of the PRC, which emphasizes party autonomy. As long as the arbitration agreement is valid and clear, parties may freely agree on the arbitration institution and the place of arbitration, regardless of whether the chosen arbitration commission has any factual connection to the dispute. Even if both parties are companies registered in Beijing and the contract is fully performed in Beijing, they may validly agree that any dispute arising out of or in connection with this contract shall be submitted to the Shanghai Arbitration Commission for arbitration. Such a clause is generally enforceable under Chinese law. Non-local arbitration clauses between domestic parties. Domestic arbitration institutions. If both parties are mainland China entities or individuals, and no foreign-related element exists, they may choose any arbitration commission within mainland China, including one located in a city unrelated to the dispute. This reflects the flexibility of arbitration and is fully lawful. Prohibition on foreign arbitration in purely domestic disputes. However, Chinese law draws a clear boundary when it comes to foreign arbitration institutions. If both parties are mainland Chinese entities or individuals, and the contract has no foreign-related element, then the parties may not validly agree to submit disputes to Hong Kong arbitration institutions or any foreign arbitration institutions, SIAC, ICC. Such an arbitration clause is generally considered invalid because it improperly treats a purely domestic disputes as foreign-related. When foreign institutions are permissible, 1. What constitutes a foreign-related element? Under Chinese judicial practice, a dispute may be considered foreign-related if, for example, one party is a foreign entity or foreign individual. The habitual residence of a party is outside mainland China. The subject matter or performance of the contract is outside China. Other circumstances that give rise to a substantial foreign connection. In such cases, parties may validly agree to arbitration outside mainland China or arbitration administered by foreign or Hong Kong arbitration institutions. The free trade zone exception. China has introduced special arbitration policies in certain free trade zones, such as the Shanghai Pilot Free Trade Zone. Under relevant judicial interpretations and policy documents, if the contract is concluded within an FTZ and at least one party is a foreign invested enterprise, a Hong Kong party, or otherwise has foreign investment attributes, then the arbitration clause may be upheld even if the arbitration institution is a foreign or Hong Kong arbitration body and the foreign-related element is relatively limited. This represents a policy-driven relaxation of traditional rules, designed to enhance China's openness and alignment with international commercial practices. Important clarification. Although foreign invested enterprises are legally considered Chinese companies, FTZ policies grant them special flexibility in dispute resolution arrangements. However, this flexibility is not nationwide. It is limited to specific regions and policy frameworks. Courts will still examine the clause carefully for compliance. Both parties are mainland Chinese. No foreign element, any mainland China Arbitration Commission. Both parties are mainland Chinese. No foreign element, foreign or Hong Kong arbitration institution is not invalid. FTZ related contract, at least one foreign invested or foreign party, foreign or Hong Kong arbitration institution, potentially while valid. Arbitration jurisdiction in China is characterized by great flexibility and party autonomy compared to court jurisdiction. Parties may freely choose arbitration institutions across different cities within mainland China even without a factual connection to the chosen location. However, this autonomy has clear legal boundaries, particularly regarding the use of foreign arbitration institutions in purely domestic disputes. With the development of free trade zones and the evolving arbitration policies, China has gradually introduced the measured flexibility to accommodate international commercial needs, while still maintaining a structured legal framework. For practitioners and contract drafters, a precise understanding of those distinctions is critical to ensuring the validity and enforceability of arbitration clauses under Chinese law.